you've been pretty successful. Obviously, you're going to the Supreme Court. Did this start in a red state, a blue state, and how's that going to affect?
It started in Washington, which is blue. It is blue, but I haven't had good success. You don't have good success. To make it to the Supreme Court, you can't have success.
You're just appealing.
Okay. Well, no. So we're not appealing. There's actually nothing to appeal. We're bringing an original civil action to the United States Supreme Court. We're invoking Article 3, original jurisdiction. We're removing the discretionary authority. But again, we're trying to reach a point where the timing is right, because ultimately this issue is the direct responsibility of the Supreme Court. Because what happened was that in 1887, under the Waite Court, and Chief Justice Waite was well known to be a slave sympathizer. I mean, he put into place numerous rulings that undermined the Reconstruction Amendments, undermined the Union, and he did it because he wanted slavery to exist. That's well known. History well known that was what Waite's intention was. He was the court that put into place Plessy versus Ferguson. In hindsight, we can understand that was not the right ruling. But he also put into place another ruling called Hurtado versus California from 1887. And what happened there was that the state of California said, you know what, we don't want to do an indictment. So they created information. Right? And they created this whole idea of information. And they said, well, we're going to do it this way, not by an indictment by a grand jury. Supreme Court came out and said, oh, that's okay. State of California, you don't have to do the indictment. You can do information, that's okay. But that's not okay, because the Supreme Court of the United States, by doing that, by creating a judge-made ruling from the court and then erroneously calling it law, they removed the fundamental right of the indictment by a grand jury that's codified and enumerated in there. They did that through judicial fiat. And then they permitted the removal of the constitutional obligation, and now the state said, okay, we can do that. And then Washington, of course, enacted their provision that says, well, the Supreme Court said we don't have to do it, so we're not going to do it. But again,
do you think they're just doing it as a time-saving method? That's all this boils down to, is they're just trying to get stuff processed through so much, and that's why this came into place in the first place.
So the absence of the grand jury in 1887 was so that they could bring arbitrary charges against those slaves that were pre-released. This was the buildup to the convict leasing era, because convict leasing was going on between 1880 and 1910, and it was the same thing. We had these people that were released and said, oh, you're no longer a slave, but then we permitted them to be able to be arrested for some arbitrary or capricious allegation, and then they would bring them in front of a justice of the peace immediately and threaten and intimidate them until they finally agreed that they were guilty, and then they would put them on a train bound for the coal mine or some other business or industry that was affected by the absence of the slavery institution or the removal of it, and they were just re-enslaving the very same people and now calling them criminals instead of slaves. But and that's well known. I mean, that history will tell you everything I'm saying. Make sure that you understand that this is the truth. This is what happened, and we're in the same situation now because once again we are literally leasing out these people to these for-profit businesses, and then not paying them anything, and and the state is receiving compensation for the leasing out of these prisoners. But that was in 1887. That was the driver. There was that the purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor or judge. It's there for the protection of the innocent. That's what it's the primary means of protecting the innocent from suffering, right? Because government can bring an accusation in the form of information, and they can arrest you for that information without validating it, because under common law, an affidavit is truth. And in fact, it's being presented as truth. That officer is saying that I present this information truthfully, factual, and correct based upon my oath, but that officer wasn't even witness. He collected that from someone else. So what happens with the information is that your right to confront your accuser evaporates, because you can't put that affidavit on the stand and cross-examine it, and that is well known. But there's also some other issues that are inherent to it, and that goes back to your question there, is that when you're charged by way of information, what happens is that judge is the one that determines whether or not there's probable cause to assume that the crime has been committed. They don't ask you as the accused, what happened. They simply take the information from the accuser, reduce it to writing, submit it to court. Court says, yep, this looks good. Go and arrest him. And now you're in a situation that's called an investigative detainment, which is not lawful either, because you're being deprived of certain liberties. You're being deprived of your ability to work and take care of your family and have a house and use your vehicle and all these things that were supposed to be preserved and protected until you're found guilty. You're actually being deprived of them from the very beginning. So this is what's known as an irrebuttable presumption of guilt. It's an irrebuttable presumption of guilt because you're being presumed as though you're guilty based upon the mere fact of being charged with a crime. So if you're being charged with a crime and you're presumed that you're guilty, now you're having all of your rights taken away from you, you're put into a jail, now you're presumed guilty based upon the mere fact of being charged with a crime. And what happens with an irrebuttable presumption of guilt is that the burden of proof shifts. Normally, the prosecutor has to prove their case. They have to prove that you're guilty beyond a reasonable doubt, because you have to be treated as though you're innocent until proven guilty, but not with an irrebuttable presumption of guilt. In an irrebuttable presumption of guilt, the burden of proof shifts. And now the defendant has to prove that they're innocent, and the prosecutor doesn't have to prove that you're guilty. And this shift actually occurs, according to Blackstone, when the system focuses on speed and efficiency as opposed to established procedures and processes. This breakdown in due process occurs when they want to push them through. That was your question, and yeah, that's why they did it, is they wanted to push the numbers through, and Blackstone says that that's exactly what will happen in an irrebuttable presumption of guilt. But we live in a world where we have procedures and processes that are established and put in place, that are agreed upon, that are taken by oath that they will preserve and that they will do. And unfortunately, if we want to change, the way that we do things, then that's up to the people. It's not up to the judicial branch. That's up to the people. It's not up to the executive branch. It's up to the people, because the people reserve the right to legislate and create laws. That's Article 1, Clause 1 of the Constitution. The judicial branch has no authority to legislate. None. That's a separation of powers issue. All legislative power is vested in the Congress of the United States. The judicial branch cannot amend the Constitution in an other than lawful manner, and yet that's what they did. So the Supreme Court of the United States is going to have to address what that court did in 1887 when they created a seditious law, because sedition is defined as the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution, to procure its alteration in an other than lawful manner.